Hello learners, I am Dr. Usha Rana, Associate Professor from School of Gender and Development Studies, Indira Gandhi National Open University, Delhi. Today's topic is surrogacy. What is the outcome of this session? Learn about the concept, types and arrangements of surrogacy and its historical development. Understand an overview of worldwide legal framework on surrogacy. Know the legitimations relating to surrogacy in India. Introduction. We all know human beings usually have a desire to have a biological offspring for the continuance of the human species and also for family and society. However, due to the variety of factors, many people are not able to have child through the biological process. In this case, in this situation, medical science has attempted to address the childlessness and offer a number of methods to have a child. In this sequence, the assisted human reproductive techniques are advanced and innovative medical development that help to people to give birth child. There are numerous types of assisting human reproductive technologies, that is artificial inseminations, in vitro fertilization, IVF, gamete intrafoveal transfer, gymote intrafoveal transfer, reproductive cloning, intracytoplastic sperm injections, and of course surrogacy, which is a topic of today's discussion. What is surrogacy and why it is important to know? Surrogacy is an arrangement in which a woman, a caring mother, agrees to bear a child and to hand over that child on the birth to another person, that commissioning parents. Means the women who carry the caring mother known as a surrogate and commissioning parents. The caring mother is called surrogate women or surrogate mother. The person whom the child will be handed over after the birth is reflected as a commissioning parents or intending parents. This definition has been given by the Oxford Dictionary of Law. The term surrogate originated from the Latin word surrogatus, and the meaning of substitute that refers to a person who is appointed to act in the place of someone else. Therefore, surrogate women, mother is someone who carries a child for another woman. C. Conceived either through the artificial inseminations of the sperm of the commissioning father or denoted gametes of the intending parents. Why surrogacy? This is another important question. Why surrogacy? As we all know, the having a children is a natural desire. It is also socio-cultural construction or significance of having a children in the one's life of continue of a heredity of their family, of their legacy, society and nation. Therefore, having a child becomes a vital, or the most of the people across the world have a desire, and they are all come with this. There are two types of infertility, medical or the social. Medical infertility is condition when a woman is not able to become parents after attempting to conceive naturally. After conceiving, she is not able to birth a child. This is a medical infertility. And social infertility refers to incapability of individuals to have a child as a result of numerous social circumstances. For example, single individuals, widows, divorced, homosexual couple, aged people, and the person have a desire to have a child, but they are not socially fertile. There are also another one group to whom is a physically unable to conceive despite being a fertile due to the serious health condition, and few people might not prepare to be the pregnant but want a child. These are the situations. There are generally two options for the pupil. First is adoption and second is surrogacy. Adoption have several legal aspects regarding the process of adoption, and second important thing, their genital linkage cannot be possible with adopted child, which can come with a surrogacy. So there is also the several especially types of surrogacy, traditional and gestational surrogacy. Surrogacy may be categorized into the two forms based on the nature of conception of the embryo, traditional surrogacy and gestational. Both are come in the same pattern. In the traditional surrogacy, the surrogate mother's egg used for the pregnancy. She can conceive either by the artificial insemination with a donor's sperm, or her eggs are fertilized with the donor's sperms in the laboratory to make embryo. In the both situations, she becomes the biological mother of a child she conceives and carries. But in the gestational surrogacy, the embryo is made through the intending parent's sperms or the eggs of a mother, the gametes and the surrogate's women impregnated by the transferring the embryo through IVF. There are very rare instances where an embryo is made from the egg and sperm, both taken from the donor and then implanted in the surrogate's women. In both the occasions, the surrogate women does not have any biological link to the baby. And another type of surrogacy is altruistic and commercial surrogacy. This category formatted on the basis of arrangements, how to arrange to conduct a surrogacy. Altruistic surrogacy, surrogate women is not given any financial or the material compensation except the required medical expenses and other pregnancy related cost, and these kind of surrogacy arrangements are made between the close friends, family or the relatives. Commercial surrogacy, the woman is compensated monetarily in the return to her energy and time put in the giving the birth to the baby, and usually a legal contract is done in between the surrogate mother and the intending parent. Through the commercial surrogacy is based on the legal contract. In many occasions, conflict of interest have emerged in between among the stakeholders of surrogacy arrangements. Now, the surrogacy arrangement in the recent time, we will go through the history how surrogacy came in existence. So, an American woman became the first paid traditional surrogate mother to give birth to a baby girl from the amount of $10,000 in 1980. She have written a book, Birth Mother, the story of America's first legal surrogate mother, which published in 1988 about the brief all detail with the motherhood which came in existence first time as a surrogate mother. Again, in 1983, the menopause women from Australia gave birth to the baby using the egg from the donor. In 1985, again first gestational surrogacy took place, paid $10,000 in Australia. Now, as we all know, what is the surrogacy in Indian context, because we are focusing on the Indian aspect of surrogacy. So, what is surrogacy in Indian geographical context or the legal or social framework? First, gestational surrogacy in India took place in 1994 in Chennai. The first surrogacy occurred in 1997. In 1999, a foreign couple from Germany became the parent through the surrogate mother. That is a journey of understanding the surrogacy history in India. In 2002, India allowed the commercial surrogacy. This was a big change in Indian surrogacy market. It became the commercial market, and within 2 to 3 years, this number of pregnancy through the surrogacy has doubled, tripled, and more. 2 decades have seen number of surrogacy arrangement in the country and made the commercial surrogacy as a global business in India. Legal framework, as the surrogacy market has been developing in India, so there was a requirement, some kind of framework for the surrogacy. Surrogacy altogether is a ban in many countries if we are going to understand the global aspect. So, like countries like France, like Germany, Switzerland, Taiwan, and some other states, particular in US. So they totally banned to surrogacy. Some countries like UK's and some states within a US and Brazil impose partially ban to the surrogacy, and the few countries have no regulation at all. So in India, as we have discussed, India emerged as a surrogacy capital of the world and opened the doors for the many national and international unfertile couple, both medically and socially unfit. So we need some kind of norms. So in this process, from the beginning, the agreement was required in between the surrogate mother and their intending parents. The surrogacy agreement is generally a contract in between the surrogate mother and intending parent, which specify the term and condition of surrogacy arrangement, how it will arrange, the compensations amount, the right, the responsibilities, liabilities, payment schedule, and other related matters. It becomes very essential and impossible or required in the case of baby M. The Malaysia was a name. The couple came from the outside and later they decided they don't want child. So several disputes emerged in that situation. So legal intervention were required. Now we will talk about little history of law of surrogacy within India. India as well as across the world considered to take services of Indian surrogate women when the commercial surrogacy was allowed in 2002, as we have discussed. Surrogacy was, what was the situation and why India became the big market of surrogacy. So there was a few characteristics within India, like surrogacy was a cheaper comparison to the other country, having a medical expertizations, and along with modern technologies. The cost of surrogacy was very important in this case. It was 1/3 fee in the compared to developed country like USA. It became a business having a turnover of $500,000. Thus, this practice came to know as a rent of womb. Yes, rent of womb. And in this all situation, Gujarat became the hub of surrogacy, having a high number of fertility clinics in the cities like Jamnagar, Anand, Surat. In view of these certain guidelines and will and legislation have been initiated by the different stakeholders of Government of India to have some kind of regulation on arrangement in surrogacy. Why? The validity of surrogacy under the Indian Constitution. First, discussing about the law, we need to understand validity, how the Indian Constitution is permitting to someone to be the surrogate mother. The Constitution of India under the Article of 21 protects the right of a life, personal liberty and the privacy and the right of earn a living. Women has a right to earn a livelihood. Surrogacy is considered as an economic labor. Her right to reproductive choice and personal liberty. The reproductive right of a citizen constitutes a fundamental right, and the concept of reproductive autonomy of the individual case. It was a very famous case in between the government of Andhra Pradesh and Pratha Charthi. That was a case came in in this contest. The commercial surrogacy without the regulation has become a mere business, where women from the poor economical background are exploited in the clinics which are established in many parts of the country. That was a part where government was focusing. And the surrogate women is put in the hostels and who should obey the instruction for the good health of the baby, and the mostly given the margin amount of their compensation after the birth of a baby. So there was a requirement, some kind of strict rules and regulations. So national guidelines for the accreditation of the supervision and regulation of ART clinics, which was the hub for surrogacy. It came in existence. The Indian Council of Medical Research issued a national guidelines to aggregate the supervision and the regulation of ART clinic in India, and also known as ICMR guidelines 2005 their name. It is specified that the value of the monetary compensation of the surrogate mother would be decided by her and the intended parents. It also mentioned that the egg of surrogate mother could not be donated for the surrogacy. She would not have any parental right over the baby. There are a number of drawbacks to the ICMR guidelines as the practices was improving, the frequency of surrogacy was improving. So there was several drawbacks, several kind of lacunas has been seen in this process. So the positive outcome of the guideline is that it acted as a blueprint in the drafting of Assisted Reproductive Technology Regulation Bill, which started from 2008 and redrafted again several times in 10, in 13, in 14, 2016, 2017, 2020 and 2022, and recently 2024 repetitively. So that was their journey of amendments as per the requirement, as per the situation which was changing. The guideline, the importance what the guideline was practicing and initiating for that, the ART clinic must not be the part of any commercial element in donor programs or the gestational surrogacy. All the expenses of surrogate mother during the period of pregnancy, postnatal care related to the pregnancy should be borne by the couple seeking for surrogacy. The surrogate mother would also be entitled to be a monetary compensation, which is very important. The age of surrogate mother has also been a significant that she should not be over 45 years, and no woman may act surrogate more than thrice in her lifetime. Payment of surrogate's mother should cover all the genuine expenses associated with the pregnancy. The ART center should not be involved in the monetary aspect of surrogate mother's health. So later, in this progress of legislation, the one law commission has came in existence, and they produced their report in 2009. The report titles Need of Legislation to Regulate Assisted Reproductive Technology Clinic as well as Right and Obligation of Parties to the surrogacy. After a lot of research and interaction with beneficiary groups from the both sides, they produced their report, and they said that consent of surrogacy mother is a must. Some cases has been seen their mother's consent was not there, their family pressure was important part in this process. So the report intended on the mother's consent. Surrogacy arrangement should provide for the financial support to the surrogate child in the event of death of the commissioning payment, divorce and other unsupportive situation. So the financial support must be there. The surrogacy contract should be necessary. Take care of the life insurance cover of surrogate mother. If something mishappening happen in this process, so her life must be covered through the insurance process. One of the intended parent should be a donor as well as because of bond and love, affection with the child, because several cases has been seen their biological belonging gives more love and care to the born one. The legislation itself should be recognize a surrogate child to be the legitimate child of the commission parents, and without there being any need to adoption or even declaration of guardian. The birth certificate of surrogate child should contain the name of their commissioning parents only. The right of privacy of a donor as well as surrogate mother should be protected. Sex selective surrogacy should be prohibited. The case of abortion should be governed by the Medical Termination Pregnancy Act 1971. This was an important aspect which was raised by the Commission. The ART regulation bill and the rules on surrogacy in India. Now we will discuss about what is the journey of a legal change in this context. It hailed surrogacy as illegal in India and upheld the practice of gestation commercial surrogacy as per the ICMR guideline, and the surrogacy was open to the all its respective nationally, gender, sexually, marital status and also infertility status. An amendment version of the bill 2012 banned surrogacy for the foreign gay couples and the single individual and allowed to married couple of at least 2 years of marriage. The ART bill 2013 puts restriction on the number of surrogacies that we has discussed also, and it was repeated again in the law. 3 live birth of a child, it was restricted, not more than that. 2014 version of a bill bar on the foreign pupil hire surrogates in India, but did not prohibited overseas citizen in India, but somehow it was in a practice after the law. The commercial surrogacy was completely prohibited under 2016 surrogacy bill, permitted only the Indian couple married for at least 5 years. In 2019, surrogacy regulation bill 16, which came in 19, was introduced in the Rajya Sabha, which permitted only the altruistic surrogacy and put total prohibition on commercial surrogacy. 2020, which was now including willing women to be the surrogate, intending the close relatives. An act of surrogacy regulation to 2021 was adopted in 25th December 2021, and it came in effect 25th January 2022 with the Honorable Law Formation Committees of India. In 2024, the amendment to surrogacy regulation rules 2022 allowed to surrogacy using a donor gametes. That was a big change in this regulation. Earlier it was a matter of discussion among the several parties, but it came in existence in 2024. Conclusion: legal provision of the regulation surrogacy as a form of ART have undergone many change across the world and in India too. There are new kind of restriction on the surrogacy, particularly on the commercial surrogacy in the most of countries across the world. Many feminists argues that rather than a total prohibition on the commercial surrogacy, active regulation would enable the exercise the right to the reproductive choice by many individuals who otherwise cannot become the parents. So this is about how the journey of surrogacy came in the world and particular in India, how the people who are not fertile in the medical and social contracts are getting a benefit to having a child. So, but now there is a need to more rural regulation. There we can protect the right of all stakeholders in this process, and the voice of women, those who became the victim in previously, their right must be addressed in this process. These are the references which can be read. Thank you very much. to be with.